Right, we're recording, so that's good. Right, Rachel, over to you.
Thank you. Okay, we're going to start then with the very topical and at times slightly thorny issue of COVID-19 vaccinations and how those bleed into the workplace and the employment relationship. In terms of the current situation, previously, a few months back, it was made clear by the UK and also the Welsh Government that the vaccine would not become a legal requirement. And that's always been the position in law in relation to vaccines under the Public Health Act of 1984. Vaccines aren't currently compulsory no matter what they're for. And it did seem at the start that that was always going to be the position and that the government wouldn't change its mind on that. But I think we have seen a bit of a shifting of the dialogue in the last few weeks and months. So you might have seen in the news yesterday, for example, that the UK government is currently considering making the vaccine mandatory in the care sector. So care workers wouldn't be able to carry on doing their jobs unless they had received the vaccine. That's something that's being considered for England only at the moment, but it's possible that the Welsh Government would follow suit if the UK government did decide to implement that. We don't yet know. There's also been talk of COVID passports being trialled in England for large-scale events as well, so football matches, festivals, concerts, things like that. And a COVID passport wouldn't just cover the vaccine, it would also cover recent tests and recent immunity if somebody has been infected in the last few months, so that they have some immunity anyway, not just from the vaccine, but it would primarily be for people who had been vaccinated, I think. So that's something that's going to be trialled for those kind of large scale events. It's not currently being looked at for smaller businesses, although some of you might have seen the comments from the Prime Minister a couple of weeks ago about landlords of pubs having to use their own discretion about whether they wanted to make proof of vaccination a requirement for entry to a venue. Now, all of this obviously throws up an awful lot of quite controversial issues. And the main issues it can throw up from a legal point of view are potential arguments over discrimination. So that could be disability discrimination, pregnancy. It could possibly be age discrimination because obviously younger age groups largely haven't been vaccinated yet, whereas older ones have. It could also be discrimination on the grounds of religion or philosophical belief. And from an employment law point of view, if these issues start to come into the workplace, we could also be looking at potential claims for unfair dismissal if things go wrong. And then there are also arguments over human rights, particularly the right to your private life and data protection angles as well. Can you move to the next slide? There we are. So from an employment law point of view, how does this work? Can staff be required to have the vaccine? Well, the short answer, of course, is no. It's not a legal requirement for anyone to have the vaccine, so an employer can't physically force somebody to take it. However, it's been discussed quite a lot in the last few weeks that sometimes it might actually be reasonable for employers to request that staff do have the vaccine before coming into the workplace. It's really going to depend there on the nature of the work, the workplace and individual circumstances as well. We think that the main scenarios in which that might be reasonable for an employer to request that of staff would be in things like care settings, possibly also settings where social distancing is very difficult, such as factories, you know, on production lines, etc. But probably mostly in a healthcare and care scenario where the risks of COVID infection are greater because of the vulnerable nature of the people who are there in that setting. So the question then arises, if an employer does decide to request that staff have the vaccine before coming into the workplace, what can the employer actually do if an employee refuses, and what comeback could an employee have? So a lot of the conversation around this has jumped straight to, can an employer decide to dismiss an employee if they refuse to take the vaccine? I think if an employer was to jump straight to dismissal, they would be looking at a very difficult to defend unfair dismissal claim, to be honest with you, because not only do we have these discrimination arguments feeding into this, but also an employer is under a duty to do what's reasonable in relation to their staff. And that would include considering whether lesser measures would be just as effective. So they could consider offering a warning. But they should also be considering things like redeployment and whether there are other things that they can do instead of asking staff to be vaccinated. And I think Fleur is going to talk about that in the next slide. Okay, so just
oh, sorry.
No, that's okay. So I was just a reminder then, I said an unfair dismissal claim would be a particular risk arising out of this. And I mentioned in the previous slide also that discrimination arguments could come into play. We think the biggest risks from a discrimination perspective would be disability discrimination for staff who potentially can't have the vaccine for health-related reasons, and also pregnancy discrimination. The other one that's been talked about a lot is discrimination on the ground of religion and philosophical belief, but it's not clear actually that a belief against the vaccine would qualify under the Equality Act as a philosophical belief that's worthy of protection. I think it's likely from a kind of public policy perspective that the tribunals wouldn't find that to be protected as a whole. So the biggest ones, as I say, will be disability and pregnancy discrimination, and in all cases, employers have got extra duties to make adjustments for their staff there. So an employer would have to be extra careful if one of those was the reason for a staff member not wanting or not being able to receive the vaccine.
Potential problem scenarios then. I'll just put some questions up here that we can sort of chew the cud on, if that's okay, because it is a sort of thorny issue, isn't it? So the first question is, do employees have the right to know if colleagues have been vaccinated? I don't know about how your workplaces are, but in this particular one, everyone's been shouting from the rooftops after having their vaccinations, because it's generated quite a lot of excitement, because people feel that it's a way out of the very bad situation we've been in. But is there an actual right for people to know whether they've been vaccinated? I don't think there really is, to be honest. It's health and safety data, it's health data, it's sensitive health data, which should be managed very carefully. I think there's a right for the employer to know who's been vaccinated, because obviously that will form part of what many employers have done in terms of how high or how low the risk of infection continues to be within the workplace. So I think employers could compile a sort of confidential list of who's been vaccinated or not, but your privacy policies in terms of GDPR and so forth should record how and what EUC will make of this data. So I think absolutely, if people want to volunteer the information, then they must feel free to do so. But I don't think that any employee in particular has got an absolute right to be told whether someone's been vaccinated or not. Can an employee then argue that not having a vaccine policy is a health and safety breach? Well, because it's advisory to have the vaccine, I think not having a vaccine policy wouldn't really be classed as a health and safety breach. However, any prudent employer, which I'm sure all of you are, will be thinking of having some form of vaccine policy, which may just say, you know, it's up to you all whether you have the vaccine or not, but we'd like to know whether you have or not. So I think it wouldn't class as a health and safety breach per se, but it's still sensible to have some form of vaccine policy for each workplace. And obviously workplaces vary. If you're sort of office-based, then the risks can be managed by social distancing and so forth, or a certain number of people in the office anyway, if people decide not to be vaccinated. But in manufacturing or factory settings, obviously it becomes more difficult if all those factors can't be played out in the same way. So I think just having a clear line on the whole thing is very sensible. Sorry, there's someone just wanting to come into the meeting. There we go, just admitted someone. So how should we deal with disputes between staff with different views on this? Well, we have to have a a culture of respect, obviously, in each workplace, and we have to acknowledge the fact that everyone's entitled to their own views, and that these different views shouldn't be sort of this, made to be points of contention effectively. I think it is a very sort of difficult issue though, isn't it? Because people do feel strongly one way or the other, and we know about people who are very against the vaccine and they're very frightened of it. I was speaking to someone this morning saying that they weren't planning on having the vaccine for the next 9 months because they wanted to see what health side effects would manifest in the population before having it themselves, which I thought was an interesting viewpoint, which I didn't comment on. But there will be a range of views on this, and we need to make sure as employers, as responsible employers, that our bullying and harassment, that our dignity at work policies and all those kinds of things are in place and are sort of suitable to reflect any sort of disputes that may arise. So remind your staff of those policies, remind people that they must be treat any views in a dignified manner, and obviously there will be grievance policies out there as well. So if someone does feel that they're being harassed or victimized or treated unfavorably because they've got a view that is contrary to the majority, then they must feel that they are able to come forward and explain themselves and to raise a grievance, obviously. Hopefully it won't come to that, but I can see scenarios where if you've got a core group of people who are, anti-vax effectively against a larger group who are very pro the whole thing and see it as the only way out, then obviously could be a very contentious issue. And as an employer, you need to be front-footing that and making sure that you effectively know your workforce as well, so you know where the potential pinch points might be. So you can handle that situation before it arises. What about pregnant and disabled staff then, who possibly cannot be vaccinated? Well, it's a difficult issue. The HSE guidance on this have basically said that there are no additional concerns specifically for any groups of vulnerable individuals. All you can do effectively is ensure that your existing controls to support and to protect them are in place. So social distancing being the key, cleaning, wiping down. And obviously if people in those categories can continue to work from home, then that clearly is the best thing for those people, because that's where they're going to be safest. Now, it's obviously not possible for everyone in these categories to work from home all the time. But when they do come in, you need to make sure that your risk assessment deals appropriately with these categories of people, not to make them feel sort of like they stand out or that they are being singled out for special treatment. But you obviously need to make sure that they are looked after in a respectful manner, which means that they need to be reassured that you've got all the protections in place, given that they cannot have the vaccine. So it's a case really of going back to your risk assessment, working out whether it's adequate for these categories of people who, through no fault of their own, cannot be vaccinated. So think about reasonable adjustments, for pregnant people as well as people who are disabled. What can you do to make their lives as safe as possible? Because ultimately this is a health and safety issue that needs consideration in keeping with the principles of reasonable adjustments within the Equality Act. So this is the last question then. What about employees who post controversial views on social media? I've had a couple of cases along these lines already, where people have particularly been working in scientific scenarios or in medicine, and even though they are working alongside developments in respect of tackling COVID-19 and vaccinations and so forth, have got their own private views, which is contrary to those of their employers, and have taken the steps of actually voicing that view on social media. So what does the employer do about that? It's very difficult, isn't it? I think you need to have a clear policy on it and explain to all your employees what is your party line as an employer and what you expect what you expect from them in terms of their conduct in general. And this is about bringing your organisation into disrepute, isn't it? If you think that their controversial views being posted on social media poses a risk to your company because they are potentially going to bring your organisation into disrepute, then you must act accordingly and let people know that you are unhappy about it, to give them a chance to rectify the situation. But if they persist with this, then obviously it becomes a disciplinary matter. And the severity of it as a disciplinary matter then depends obviously on the content of what they have said, and also, you know, how far reaching is it, how identifiable are you as an employer from the content of what they've said, how contradictory the comments are, and so forth. So lots of factors to consider there, but certainly it's not something to go, oh well, there we go, everyone's entitled to their views and we won't do anything about it. If you think it's a risk to your organisation, you have every right to take them up on it. So moving to the next slide. Oh, this my computer is not liking me today. Sorry about this. Here we go. So just to recap on some tips for you all. Communication, redeployment, discrimination and data protection. These are all key factors which you need to consider in the context of this vaccination issue. Communication is always king of every scenario involving HR issues, isn't it? People need to understand where you as an organisation sit or view the vaccination programme, what you would, you know, in an ideal world like to happen. I think that's right. As Rachel mentioned, we can request people, but we can't force people to take it. Make sure as well that you may be in a position where you can fill a gap here, because there is a lot of misinformation out there on social media and other platforms about the vaccine and about the side effects and so forth. But if you feel comfortable to bring together some additional information to allow your employees to make informed decisions, then you can feel free to do that, because as long as you're using, you know, official sources, obviously. But I think, you know, employers do actually have a role to play here. This is a public health issue, and employers shouldn't feel shy from voicing their opinions and making sure that staff have got the tools to make their own informed decisions about it. And that then boils down to communication in general, doesn't it? Obviously, people who don't want to receive the vaccine, some people obviously can't, as we discussed, and we've discussed how to handle those in accordance with the risk assessment. Those who won't or just feel fearful of it, it may be impossible to keep them doing the role they were doing, and therefore you might need to think of redeployment if that's the case. And it's something that you probably get quite a lot of resistance to, because people are saying, well, it's perfectly safe for me to continue to do my role. But if you are satisfied that that person continuing to do their role without the vaccine poses a health and safety risk to others and to themselves, then clearly you can actually do something about that, and redeployment is one option for you. Rachel's already discussed discrimination. This is a key issue here. I'm yet to find anyone saying that they won't be vaccinated because of their religion or a certain belief, but it's early days, obviously, and I think that day will come. But obviously, people who have health conditions, which means that the current vaccinations out there are not suitable for them, then you need to be mindful of that and make sure you deal with them in keeping with the provisions of the Equality Act, and that reasonable adjustments being key here to try and make sure that they're safe. Data protection, as I said, this is sensitive personal data. It refers to your health and your well-being. Therefore, your HR officers need to make sure that this information is kept very safely if you are going to collect it. I think from what I understand, most employers are intending to keep a record of who is sort of vaccinated or not, because it kind of keeps in keeping with the risk assessment approach that we've all had to adopt. But make sure that you're fully up to date with your provisions under the Data Protection Act 2018 and update your privacy policies accordingly. Rachel.
Okay, moving to the more general considerations in terms of bringing people back into the workplace in due course. This is something that a lot of employers will be starting to plan for, but not necessarily implementing just yet. The current position in Wales is that shielding has now officially ended. So it ended on the 1st of April, I think. But the regulations and guidance on working from home still remain in place. So the official position is still, if it's possible for you to work at home, then you must do so. And you can only go into your workplace if it's not reasonably practical for you to work from home. That said, I think there is some flexibility over the meaning of what's reasonably practical, and a lot of employers and employees are taking the viewpoint that if they think it's better for their well-being, their productivity and their business to come into the office or the workplace every once in a while, or indeed on a full-time basis, then they can argue that it's not reasonably practical for them to work from home. And I think we are starting to see more footfall in terms of people returning to the workplace, whether on a part-time or a full-time basis. Certainly it seems like public transport seems to be filling up. You know, shops are reopening, the hospitality sector will be reopening in a couple of weeks in terms of pubs and restaurants. So it is starting to happen. People are starting to return to the workplace, and this is something that employers need to plan for now, I think, really. So as I said, the health and safety rules from the Welsh Government remain in place, and that doesn't just relate to the requirement to work from home where possible, but it also relates to what employers need to do if they do have staff working in the workplace. So the main one there is, of course, risk assessments. All employers have a duty to make a COVID-19 risk assessment, and those with over 5 staff have a duty to write that risk assessment down. And this is something that should also be shared with all staff as well. In the case of larger employers, there's also a duty to publish that risk assessment on the employer's website. But for most employers, it will be a matter of making it in writing and sharing it with their staff and consulting on it with their staff if necessary. And if anybody has any concerns about it, and discussing that with them and possibly adjusting that risk assessment to make sure that everyone's comfortable with the measures that are in place. There will be a lot of people out there, I think, who are quite anxious about returning to the workplace, especially after it's been so long. You know, it's been over a year now since a lot of people have started working from home. So coming back into the workplace for the first time will be seen as quite a big deal by a lot of people. And some people might have actually developed anxiety or other mental health conditions over the period of lockdown. But some people might just be feeling generally anxious and concerned about returning to work, possibly either because they have an underlying health condition which makes them vulnerable, or because somebody that they live with or that they're close to does, or just generally because they don't like travelling to work. The idea of travelling to work on public transport when you just don't know, you know, what the circumstances of the people around you are really. So employers need to approach this quite carefully, I think. At the moment, as I said, there's no right for employers to force people to return to the office, because the official line is that people should still be working from home where possible. I think it's fine for employers to start inviting staff to consider returning to their office and to discuss that with them and to make a plan for it for the next few months, because it's likely that that guidance and those regulations will change from probably around June onwards. Certainly the UK government have said that from the 21st of June that rule on working from home will be reversed. The Welsh government might not do it quite so quickly, but I think over the summer they will drop that requirement, so a lot more people will be returning to the office. So in terms of planning, as Claire said in the previous slide, communication is going to be really key. Employers need to discuss with staff what their intentions are, what their concerns are, but also make it clear what the employer's own expectations are as well. Some employers, we've seen in the news, will be asking their staff to return full time because some employers just don't like the idea of home working. Some on the other end of the scale are actually considering making home working a permanent fixture and reducing their office space. And a lot will be willing to be a bit more flexible and take the kind of middle ground of part home working, part office working. But I think communication with staff on an individual basis is going to be really important here. You might start with possibly a staff survey, so you could contact all of your employees and ask them on a no obligation basis what their preferences would be, and that might be a good way of you starting to plan what you can and what you should do. Now, if an employer does try and force staff to come back to the workplace against their wishes, we think there are potential arguments in terms of constructive dismissal or discrimination. On constructive dismissal, most of you might know that that's when an employee feels forced to resign and claims that they've been dismissed by the employer because the employer has breached their employment contract in such a fundamental way that they've had no choice but to resign. I think at the moment, given that the legislation in place is still that employees do have the right to work from home and should be working from home unless it's not possible, if an employer breached that and tried to force staff to come back to work early, then that could well be a fundamental breach of the employment contract. And that could easily give rise to a constructive dismissal claim, I think, if the employee was to refuse and to resign. So it's important that employers don't jump the gun on this. While that guidance remains in place, they can't force staff to come back to the workplace, but that might change in a few months' time. And particularly if an employer feels that its productivity and its business have suffered as a result of home working, then at that point it will probably be seen as a lot more reasonable to ask staff to come back into the workplace. In terms of discrimination, I think the same arguments might apply here as in relation to the vaccine. It will be particularly relevant to staff with disabilities, where there's a duty to make reasonable adjustments, and possibly also pregnant staff as well who might not feel safe coming in. So these are considerations that you need to bear in mind all the time, and just approach it on a case-by-case basis, I think, in relation to each individual employee. So in terms of managing the return to work, the furlough scheme, the coronavirus job retention scheme, as it stands, it's been extended until the 30th of September, and flexible furlough is available. So for those of you who don't know, flexible furlough means that people can be furloughed on a part-time basis. So they can be asked to come back to work for part of the time, and for those of their normal hours which they're not working and they're furloughed, the employer can still claim back furlough pay under the coronavirus job retention scheme. So that's a potentially useful tool for employers who have staff who have been fully furloughed up to now but want to start bringing people back into the workplace. It can be done on kind of a phased basis, and it gives the employers a lot of flexibility. I think you need to approach this sensibly and make a proper plan in terms of thinking about which of your teams and which of your staff might benefit from returning to work first. And that's where a staff survey might come in handy, possibly, so that you can find out what issues people have in terms of returning to work, but also which parts of your business might have suffered as a result of home working, and where you really feel that bringing people back into the workplace would be helpful. Of course, you do need to think about whether continuing to work from home is still possible and practicable, certainly until at least June. After that, it's likely to be more reasonable to ask people to start coming back. But at the moment, if it is possible for people to work from home and they do still want to do so, then I think you need to really allow them to do that. Now, the next one is quite an interesting one. Have contracts of employment been amended? A contract of employment can be amended either expressly or sometimes by implication. So if we look at express amendments first, some employers might have agreed with staff back at the start of lockdown or some other time during the last few months that their contracts will be amended so that their workplace becomes their home rather than their office or their previous workplace. If that's been drafted in such a way that it's a permanent amendment, then that is then part of their contract. So if you want to start bringing staff back into the office, you are going to need to re-amend the contract. And that should be done through consultation and then through making an agreement in writing with staff, even if that's just a contract variation letter. It's also possible that contracts can be amended by way of furlough agreements. And most furlough agreements that I've seen, I think, make it clear that these changes are temporary. But if they don't, then again, it would be very sensible to make another agreement with staff in writing that they will come back to the office and that their furlough is coming to an end. Now, in relation to amending contracts by implication, it's sometimes possible for this to be done by what we call custom and practice. So if a change has been made, but it hasn't been agreed or recorded in writing, but it has gone on for such a long time and everyone has just stuck to it for such a long time, that it has become the norm, it could be possible to argue that that contract has been amended through custom and practice. Now, I think it's unlikely here that most contracts of employment have been amended at this stage through custom and practice, because if we think about everyone's intentions, back at the start of lockdown, a lot of people envisaged that they would be working at home only for a few weeks at a time, and it's really been extended only in increments as more announcements about further lockdowns and further changes to the rules, etc., have come in. So I don't think anyone has really envisaged at the start of this that that would be a permanent change. It's just been necessary because of the changing circumstances. So my view is that it's not really a custom and practice issue at this point. I don't think contracts will have been amended by implication unless there's been some kind of display of intentions by the parties that it would be a permanent arrangement. But in any case, I think whatever you're going to do and whatever contract variations you've had in place so far, when you do start bringing staff back into the workplace, you need to do that through consultation and ideally keep some kind of written record of them agreeing to whatever you do agree between you. On a more practical level, when you're bringing staff back, in terms of your risk assessments, etc., of course, you do need to consider the space that you have available in the workplace for social distancing purposes. Those of you who have smaller offices or smaller workstation spaces might want to consider bringing staff back in shifts or on a rota basis so that you only have, say, a third of staff in on any given day, so that everyone is able to still stay 2 meters apart while that rule is still in place. And then, as I said in the previous slide, ensure your risk assessment is available to all staff. For those businesses with over 5 employees, it has to be a written risk assessment. But for smaller businesses, it's sensible to do it in writing anyway, just in case. Make sure you do share it with staff, that you're very open with them about it, and that you invite them to share any concerns about it with you as well when you're having these return to work discussions with them. Okay. You're muted, Fair.
I'm not muted now. Sorry. So a few tips for you on the back of what Rachel's just discussed. Risk assessments. There we go. Risk assessments obviously are key in this process. Keep on top of all the changes in health and safety rules and guidances, and obviously remember there is a difference between what's statutory requirements and what is guidance from the government as well. And obviously if you've got any operations in England, you need to keep an eye on what's happening in England from the UK government as well as from Welsh government. So there's quite a lot as HR people that you need to sort of keep an eye out on. And sometimes the media do quite a bad job of reporting that dash often, and they will say things that actually aren't exactly correct. So we'll try and dig out any actual guidances and any regulations out there, because there's nothing better than checking it for yourself and not just accepting what might be on Wales Online or on the BBC or whatever, because sometimes the nuance is lost in the way people report these things. And also remember, the risk assessment has to be a live issue. It has to be something that is looked at every few weeks or at least every month, to make sure that it continues to be adequate for the requirements of your organisation. Because let's not forget, we've been on a on a very substantial journey here, haven't we? From the first lockdown, where pretty much everyone was at home the whole time, to quite a lot of relaxation of the rules over the summer months, and then back into a very tight lockdown over the last few months. And now, obviously, as I was saying earlier, just the shoots of spring, bringing with us the prospect of a gradual return to the office. So your risk assessment needs to be cognizant of those changes, and you need to make sure that it's suitable for where you are as an organisation at this moment in time. And it's not just about having the risk assessment. Obviously, you need to make sure that you communicate it with your staff regularly. We try and do that every few weeks here, or at least every month, to make sure that people are reminded not only of the fact that we are still in the middle of a pandemic and therefore we need to act responsibly towards each other, but also just to reassure employees that you are taking this seriously, that you are adhering to the requirements of the risk assessment, and that, you know, this is no laughing matter. And obviously, if people then breach that risk assessment, there will be consequences effectively, because, you know, we can't mess about with the situation, can we? And then on a slightly kinder note, flexibility obviously remains incredibly important. We've got a range of arrangements here within my firm where people are still mainly working from home, but there's been a sort of pattern of people starting to come in now and again, particularly at the sort of more junior level where there's more support needed and more supervision and so forth. But flexibility is key, and, you know, you need to treat each individual according to their individual circumstances, because you know, some people have got caring responsibilities or are living with people who are still vulnerable, etc. So flexibility is incredibly important. Holidays now, change of topic altogether. I don't know how up to date you all are with the holiday situation at the moment, but I'll just put a couple of points on here that I'll go through with you. So obviously the UK government published the working time coronavirus, I should be able to say that by now, shouldn't I? Coronavirus Amendment Regulations 2020. And don't forget that these remain in place. And what they basically say is that workers can carry up to 4 weeks of unused leave from 2020 into the next 2 leave years, but only where it is not reasonably practicable for a worker to have taken their holidays effectively. So there will be key sectors, clearly medical sector, care sector and so forth, where people just haven't been able to take any leave, which probably has been very bad for them, along with the stress of the situation. So they will be able to take that time off over the next 2 years, or 4 weeks anyway. So do bear that in mind. I think most of you will have been managing holidays as you go along, but I did hear of quite a lot of organisations realising that their holiday year was coming to an end, either at the end of December or the end of March, and having a big scramble to make sure people took loads of holidays, which then caused a bit of problems in production and productivity and so forth. So you know, now's the time really to take a long view of your holiday requirements and also your work requirements, to make sure people are staggered, because I, for one, think that this summer is going to be quite tricky in terms of all that, because when things loosen up, so, you know, shops have opened now, pubs and restaurants are starting to open slowly on the 26th of April, aren't they? And then through to May, there'll be gradual easing of restrictions even more. And I don't know of any person really who's not looking forward to having some time off and have the ability, you know, when we can go somewhere and do something. And go and have a nice meal or whatever takes your fancy. So I think as an employer and as an HR person, you need to be on the ball with this to make sure that you don't suddenly realise that there's no soul around to do any of the work that still needs to be doing during that sort of crucial period from, say, May through to September. Obviously mindful of people's childcare commitments and so forth as well, but it's a bit of a balance, I think, between avoiding a large backlog of holiday building up to the end of the holiday year, and actually making sure that when everyone does want to take time off, that they can do so in a staggered way. If you're requiring people to take holiday, then obviously you need to make sure you give them adequate notice of that, which has to be twice as long as the period of holiday that you are asking them to take. So if you want someone to take a week off in May, then you need to give them at least 2 weeks notice that that is what's required of them, so they've got adequate time to plan their diaries and to make arrangements, and that's an actual requirement under the working time regulation. So don't think you can just turn around and go, oh, by the way, tomorrow I want you to take a day off, because the employee will have every right to say that that's not really fair if that's the case. And obviously our holiday provisions are kept in our contracts and our holiday policies, so make sure that those are up to date. And some of you may not have bothered to update them to reflect the working time coronavirus regulations. That doesn't really matter, because the statutory provisions would override whatever's in the contracts anyway. But do check your contracts, and the most sort of prudent thing to do here is to make sure you keep an eye on holiday and manage it so that it doesn't become a big issue towards the end of the leave year, or, as I say, as we go along through these hopefully exciting summer months.
Okay, just a quick word then on how holidays interact with furlough leave. Would you mind just muting your mic there? I'm getting a bit of feedback. Thanks. So the key position is that furlough itself is completely separate from annual leave rights under the working time regulations. Furlough doesn't amend any of those leave rights. So what that firstly means is that holiday still accrues during furlough. So even if staff have been not working at all, even if they've been having a break, even if they've been able to go away during a period of furlough, that doesn't mean that they're treated as being on holiday. Their holiday still continues to accrue during furlough because they are still employed by you during furlough. So that position isn't amended by the Coronavirus Job Retention Scheme at all. And what that potentially means is that somebody who's been on furlough for the last few months or even a year might have been accruing their holiday without really bothering to take it, because why would you bother booking a period of annual leave if you're already not working? So you might then find that your furlough staff have a backlog of holiday just before they're due to return to work. However, holiday can still be taken during furlough, so you can still ask your staff to book leave while they're off. And as Claire said, you can do that by giving them twice the length of notice as the period of leave that you're asking them to take. I've put there, is this always the case in terms of taking leave during furlough? Because there were some questions last year over whether if somebody is shielding, they can really be treated as on holiday and really be asked to take a period of holiday if they can't even leave their house. The reason for this is that the concept of annual leave, which comes from EU law, the purpose of annual leave is to take a period of rest and recuperation. So there were questions last year over whether if somebody is shielding and isn't able to leave their house or go anywhere or do anything, they can really be treated as having a period of rest and recuperation. So we might have seen arguments over people being forced to take leave when they were shielding and not really seeing it as meaningful leave and kind of resenting being forced to do that. I think it's less of an issue now that shielding has come to an end, but there were questions over it, so there could still be arguments over it hanging over those employers who might have had those issues last year and up until the 1st of April. Now, in relation to furlough and holiday pay, it is possible to keep somebody on furlough while they're on holiday, which means claiming back the 80% salary as it currently is under the Coronavirus Job Retention Scheme. But because furlough doesn't affect annual leave rights under the working time regulations, the right to receive holiday pay still remains as the right to receive 100% of holiday pay. So an employer can claim back 80% of that sum, but it must top up the remaining 20% and pay that to staff while they're on designated periods of annual leave. And if you don't do that, you could potentially face a claim under the working time regulations or a claim for unlawful deduction from wages, because holiday pay is a really important right. So it's really important that employers pay it correctly at 100% and then just claim back 80% of it under the scheme. Contractual entitlements, it's always important to just check your contracts and policies, because they might be slightly different from the statutory positions under the working time regulations. In particular, you might have different notice requirements for taking holidays, and you might have more generous enhanced annual leave entitlements. You might also have provisions on when extra entitlements can be carried over into the next leave year. So even though the position under the coronavirus amendment regs is that only 4 weeks holiday can be carried over into the next 2 holiday years, you might actually find that your contracts allow more than that to be carried over as well. So just always check that position. Okay. Finishing then on just a few tips for the employer to summarise in relation to annual leave. Well, workforce planning is really, really important. So on a regular basis, you should be checking how much annual leave staff have outstanding. So what your overall backlog of leave is, whether there is anybody who has a particularly large backlog, and also think about what particularly busy or quiet periods you might have coming up. So thinking, as Faye said, possibly about the summer in particular, is that going to be a time when you need all hands to be on deck? Or is it going to be a time when things might be winding down a bit, and it's a good opportunity for you to ask staff to start using up some of their leaves? Plan ahead and really think about what is going to be right for each team and each part of your business. Communication, then once again, as always, tell staff about your policy on taking annual leave. So if you are going to start asking them to use up leave during each quarter or during a particular period of time, you should communicate that to staff well in advance. And even though there's minimum notice periods under the working time regs, that doesn't mean that you can't give them longer notice as well if you've already thought about it longer in advance than that. Support, obviously the purpose of annual leave, as I said, is for taking rest and recuperation, and if staff aren't taking leave, that potentially then becomes a well-being issue. So from a moral and a practical perspective, as well as a legal one, it's really important to encourage staff to be taking their leave regularly, not to be going long periods without taking leave and storing it up, and making sure that they get that rest and recuperation for their own well-being. And then finally, consistency. It's really important to make sure that whatever policies you have in place, you apply those policies fairly, to make sure that there's no disproportionate impact on any particular groups of employees. Flea mentioned childcare earlier, and that's an important one. You might want to bear in mind that any policies you do put in place might disproportionately impact those with childcare and responsibilities. And from a discrimination point of view, sometimes policies like that can indirectly impact more on women, obviously, because those statistically have the more childcare responsibility. So in some cases that can lead to indirect sex discrimination claims. So if you just think through your policies carefully, you make sure you're as consistent as possible, you should be fine on that. Okay.
So that's it from us today in terms of the slide content we wanted to go through with you. I've seen there are some comments and some good questions in the chat function, so I'll just go and look at those quickly now. Yes, we will be sharing the slides, and we will make sure that they go out with this recording in case anyone else within your organisations want to have a listen as well. There's a couple of questions about, I think, the slide I dealt with, which was the one with the questions posed in it, which is about do employees have the right to know if colleagues have been vaccinated? I think that's the question that some people have asked for clarification on. So one question in the chat is about whether the answer I gave to that question would change if it was proven that the vaccination actually stops the passing of the virus. And then another question is about whether the answer to that question would change if you're dealing with managing someone who's pregnant or with a disability, in terms of what you can tell them about who their colleagues, how many of them have been vaccinated and so forth. I don't actually think that my answer changes to that question, despite the sort of points you raise, because ultimately, as I said, that whether you've been vaccinated or not is sensitive personal data, and it will remain so even if there are factors which influence that. But what you could do potentially is put something in your privacy policy that says that in certain circumstances you may see fit to share that information. For example, not so much for if it's proven it stops the passing of the virus. I don't think that would be reasonable to as a factor to change the answer. But obviously, if you've got people who are very nervous because of their pregnancy or their disability, it may be seen reasonable to share that information. But if you're still not sure, what you could do is ask for the people who are affected's consent before you do that and share that sensitive personal information with other people. So I think it's a qualified change to the answer, excuse me, rather than being a categoric yes, that would definitely change things. You'd need to A, make sure your privacy policy reflects what you are going to be doing with such sensitive personal data, and B, consider, I think, probably getting people's consent before doing so. Another question was about youth work, where staff can't work from home and have front face with young people on activities, even if they're socially distanced. This goes back to one of the slides Rachel dealt with, I think, doesn't it, Rachel, about when it's reasonable for an employer to request an employee to have a vaccination. Do you want to come in on that?
Yeah, I think it's potentially a factor in whether you can request that people have the vaccine, and there's no real harm in requesting as long as you're not punishing people for declining to do that. But I think if it is possible for them to do that work socially distanced and with appropriate protections in place, potentially PPE, but social distancing, ventilation, it might be outside, etc. If those other protections can be put in place, then it's arguable that there's no real need for you to request that they do have the vaccine, because there are enough measures in place to protect them and the people that they work with. So the question of what's reasonable in the circumstances obviously isn't a clear-cut one, but I would say that in relatively safe situations, it's not necessarily going to be reasonable for you to put pressure on staff to have the vaccine. As Flea said earlier, the vaccine is currently advisory only in law, it's not compulsory. So you really need to think carefully, I think, before pressuring staff to do that.
Thank you, Rachel. And then one person has made the very correct comment that there are potential religious objections due to the use of animal testing and fetal material in the development of the vaccines. And of course, yes, those would be factors you'd need to take into consideration if someone takes that view that they're not prepared to be vaccinated on those grounds, and that will be something I'm sure will be tested in the courts. If people are basically feel they're forced to do something despite their religious objection to them. Mary then mentioning why isn't COVID effectively made mandatory to NHS staff, etc. I think that's right. Well, there's been a lot of debate, hasn't there, about that and whether it can be made mandatory. But at the moment, it's not been added into a list of mandatory vaccinations. I think the government are probably looking at this. I read somewhere there's a lot of psychology involved here, where they basically want to encourage people to take it, and in the hope that sufficient numbers of us do take it. before basically taking a call on whether to make it mandatory on the grounds of public health. Because they think that effectively, if you start saying to people you've got to have it, it will mean that even less of us will actually take that, do what is required of us. So I think we probably need to watch this space, particularly in some sectors where obviously there's going to, you know, if you're in close exposure to people who've got COVID, obviously there may well be a requirement to look at that again.
I think also, sorry Claire, just to jump in, I think that there are tricky considerations in making vaccines compulsory in the care and health sectors, especially in the care sector, I think, because the concern is that that could add to what is already a recruitment crisis. So if large numbers of staff are put off working in care because they don't want to be required to have the vaccine, that could make the recruitment crisis in the care sector worse. So it's certainly something that the government is going to have to think through very, very carefully before it decides to take that step.
Turning to the next comment, someone's asking whether if an employer's been clear by email, Teams meetings and messages that working from home is just a temporary measure and that they will be looking at agile working going forward, whether that's sufficient. And obviously, yes, my view is absolutely that's sufficient. But as long as you've communicated that to people and people don't have a false expectation that they're going to be working from home forever. So you need to look back at how you've communicated that to satisfy yourself that you have actually dealt with it adequately, so that there's no problem of people turning around and saying, I thought that this was it forever and you are now breaching my contract by making me come back a few days of the week. In terms of standard documents, surveys and risk assessments and so forth, we have got some templates. So I suggest, Sheila, you get in touch if you want us to assist you with that. What's the next question? Can you remind me on PH generally if part-time staff? Sorry, I'm not. What is that question? By Alison.
Sorry, I meant public holidays during COVID. Yeah, sorry.
So you public holiday generally, if part-time may only work very few hours per week on a different day of the week, particularly during COVID. It would be the same as your normal policies on public holidays, I believe.
Yeah, I think so. So if staff would normally work on a bank holiday, then they have the right to have a day off in lieu of that bank holiday. So it really depends on what they would normally do and what it says in your contracts also. But essentially, you need to make sure that nobody is missing out on the right to have 5.6 weeks holiday a year, including bank holidays.
And then the next question refers to whether the contractual provisions override the statutory provisions, and it's the other way around. The statutory provisions come first, and then the contractual position second. So if there are changes to the statutory provisions on holiday, like the coronavirus regulations we've mentioned during the presentation, then they would override your contractual provisions on holiday. But obviously, as I said, the 4-week carryover is only in circumstances where people really have not been able to take the holiday. It's not like a divine right that suddenly you can just park taking holidays and take it at your leisure. If you've been able to take holiday, which lots of sectors have been, even though there's been nowhere to go to, then they're not of particular relevance to the situation. And then I think that's just some comments, which are very kind. Thank you very much, all of you, for those. I do hope it's been helpful to you. And you know where we are. This is the first in a series of 4, I think we are delivering. I'll be doing this one in Welsh as well. So if you've got any Welsh speaking colleagues who may be interested, I'm going to do a recording of that one. And yes, we look forward to seeing you for the next session, which is, I can't remember when. Rachel, can you?
Next week, next Thursday, I think.
Next Thursday, there we go. So yes, if you'd like to tune in then, that would be great, and nice to see some of your familiar faces from well, this time last year, wasn't it, when we started doing these in conjunction with WCBA. So thank you very much, everybody, and have a good day. Thank you. Bye.